Hello and welcome. I am Dr. Manvendra Kumar Tiwari and I am an associate professor at the Dharmshastra National Law University, Jabalpur. Today, as part of our legal reasoning discourse, we will discuss about judicial precedents. Judicial precedents are a source of law, and judicial precedent is based on a rule of Latin maxim which states stare decisis et non quota movere, and it is popularly known as the rule of stare decisis, that is to stand by what has been decided. So decisions of the constitutional courts or top courts in common law countries are taken as the source of law. It is binding on all the courts subordinate to it, and at the same time, the law declared is a source of law. Judicial precedents of Supreme Court and High Courts are a source of law in India, but courts also don't make law. Sometimes this gives rise to a confusion. If judicial precedents are a source of law, then why do we say that the courts do not make law? Is there a contradiction? Now, so far as the theory of law is concerned, there is no contradiction. Judicial precedents are rightly a source of law, and yet courts do not make law. Now, what do we mean by that? Now, judicial precedents are the interpretations of the court of the given law, interpretations made by the court of an existing law. And therefore, that interpretation adds to the existing mass of law. Yet, so far as law making is concerned, the art or task of interpretation is not considered the task of making law. So this is how we reconcile this conundrum when we say judges don't make law, yet judicial precedents made by the same judges forms part of the law. How do we reconcile this? We reconcile this by stating that judges don't make law, but judges do add to the existing law by interpreting the existing law. So therefore, that interpretation is a source of law. That interpretation placed is the source of law, but that interpretation is not considered an act of law making. That is how we reconcile this confusion. Now, so far as judicial precedents are concerned, I told you that in common law systems are the systems which largely borrowed their principles of legal systems from the British legal system. And the common law systems follow the system of binding judicial precedents, whereas the civil law systems, inspired by the Roman law system, and countries which are governed by it are called civil law systems or continental law systems. In continental law systems, the judicial precedents of the top courts or constitutional courts remain persuasive and they are not binding precedents. Now, why is this distinction? Now, first of all, there are pros and cons of both systems, and therefore it ultimately boils down to what choice a particular legal system is going to make. In common law countries, the general the inclination is always towards considering judicial precedents of top courts and constitutional courts to be binding, whereas in civil law systems, the trend has been to not consider judicial precedents binding, rather it remains persuasive. Now, what could be the justification for such a distinction? The justification, so far as common law is concerned, is in the fact that the principles of equality, the principle of equality is considered very dear, and therefore, if a person has been treated in a certain manner following the application of a law, then unless that interpretation placed is declared wrong, the other person similarly situated should also be treated in the same manner. And that's why the idea being that if judicial precedents have a binding effect, then there is the principle of equality that is maintained. Whereas if the judicial precedents are not binding, then it may result in similarly situated persons being treated not equally. Whereas in civil law systems would consider that one should not be bound by what has already been decided, and in every case, what is right should be done. Okay, and therefore, if the system of binding judicial precedents would remain, then if the binding precedent happens to be wrong, then unless that binding precedent is declared to be an invalid law, then all future decisions must also be wrong. And therefore, civil law system tends to give this discretion to the judges that they are to be persuaded only by the logic of the precedents, but the logic of the precedent no way can bind their discretion. So that is roughly the logic so far as following one system over the other is concerned. But generally, it is the trend that when it comes to common law systems like UK, USA, India, one finds that there is a system of binding judicial precedents, whereas when it comes to civil law or continental law systems like France, like Latin American countries, the trend has been to not have the system of binding judicial precedents. Now, what is binding? Whether the decision is binding, so far as the decision of a decision is concerned, the decision only binds the parties, because decision would say that A has to give this particular thing to B. So therefore, this decision would only bind A and B, the parties to the case. So therefore, what do we mean when we say that the decision of a constitutional court or top court would give rise to a binding or a judicial precedent? What this judicial precedent is? So therefore, here we learn that the ratio decidendi of the judgment is binding and not the obiter dicta. So only the ratio decidendi of the judgment is binding. So what is ratio decidendi? Ratio decidendi means reason for the decision or reasons for the decision if there are more than one reasons. Okay. Likewise, obiter dicta are observations of the court on the issues or questions which were not to be decided by the case. That means only in respect of those questions which the court was called upon to adjudicate. When the court decides those questions, the logic or the reasoning followed by the court in deciding those questions become precedents for future. Whereas sometimes what happens that sometimes courts may even pronounce their decision or they may make some observation in respect of issues and question which were not to be decided. They might be ancillary, closely connected with the issue to be decided, and yet because of the close nexus of an issue with the central issue which is to be decided, the court may, even in respect of those ancillary questions, may give its observation or may even say what is right and what is wrong in respect of that question also. If that is the case, then that observation or that particular reasoning for the observation becomes part of what we call obiter dicta. And obiter dicta are not binding. The reason being that the courts get the opportunity to decide for a reason. And that reason is that there is a question that is to be decided. And therefore, when the court decides that question, it gives rise to a precedent. But if a question is not to be decided and yet the court will answer the question, then that in a way is an inappropriate exercise of the opportunity to adjudicate, because the opportunity to adjudicate comes only when a question comes before the court via a petition that is filed. If the petition is not raising that question, if even then such an answer is even then a question is answered by the court, that there was no occasion for the court to answer that question, and that's why that is considered obiter dicta. There are other reasons also as to why obiter dicta is not considered a binding precedent, because if that question was not germane to the issue that the court had to decide, then the parties would not even present their arguments on that question. And that's why the court will never have the opportunity in respect of those questions to hear the both sides. And that is why a decision on that question is more likely to be not expansive enough in terms of the factors which ought to be taken into account while making a final judgment about those questions. And that is why obiter dicta, again for this reason also, is not a binding precedent. Now we'll see the relevant constitutional provision. Now, so far as the Supreme Court of India is concerned, there is Article 141 of the Constitution, and there is, however, no corresponding provision for the High Court, which says which gives precedential value to the judgments of the High Court. But because, like is the Supreme Court is a court of record under Article 129 of the Constitution. Likewise, High Court is also a court of record under Article 215. A court of record is a court which can punish for its own contempt, and a court of record is a court whose decisions are preserved for perpetual memory. And both Supreme Court and High Courts are courts of record. So following this logic, High Court's judgments also in a way have precedential value. Apart from that, Article 227, which gives to the High Courts the power of judicial superintendence over the courts in its territory, and Article 235, which gives administrative power to the High Courts over the services of the judges of the territory in which the High Court exercises jurisdiction. So, reading these provisions 227, 235, and 215 together, we say that, like is the case with Supreme Court, High Court's judgment also possess the binding character so far as the jurisdiction, so far as the territory in which the High Court has the jurisdiction. We'll see these provisions as to what these provisions actually say. Article 141, law declared by the Supreme Court to be binding on all courts. So it says law declared. Now, declared also in law has a very specific meaning. Whenever you come across the term declared, declare in law means declaring something that already exists. So this also is the reason why we say judges are not supposed to make law. Judges are supposed to declare law. Howsoever innovative that may be, but that reading has to flow from the already existing law. And if that is the case, we call it law declared and not law made. So the law declared by the Supreme Court shall be binding on all courts within the territory of India. This is what Article 141 says. And we should also keep in mind that though it is binding on all the courts within the territory of India, it does not mean that it is not binding on the government, that it is not binding on the executive. That is certainly not the case. It is binding on all the courts. That is what is there in Article 141. But if the Supreme Court has passed an order, then the precedent is for entire country. And that's why executive, legislature, judiciary, all are bound by the judgments of the Supreme Court. 215, High Courts to be a court of record, and 227, power of superintendence over all courts by the High Courts and control over subordinate courts. I already told you. So these are three provisions which taken together would mean that High Court's judgment should also have precedential value in the territory over which the High Courts exercise jurisdiction. Because how can you say that the High Courts have control over subordinate courts if the subordinate courts are not following the judgments of the High Court? Likewise, how is the High Court able to exercise superintendence over courts if the courts are not following the precedents of the High Court? So therefore, taking this together, we say that High Courts also High court judgments also have the precedential value, binding precedential value, but only in respect of the territory on which the High Court exercises, in which the High Court exercises jurisdiction. Now, how the ratio decidendi, we popularly call it ratio. How is ratio deciphered or ascertained? Now, deciphering or ascertaining ratio, it can be very difficult because the courts only decide and the courts tell the reasons for the decision. But the courts never spell out the ratio decidendi of their decision. So it remains to be ascertained by the future lawyers, future judges, as to what was the ratio of a given case. And that is why this, in a way, may give rise to confusion as to what was actually the ratio of a case. And that's why this task, every time there is an argument that there is a precedent, one has to actually establish that the precedent that one is talking about is actually the ratio of a decision of the court. Only if the court is convinced by the argument that this in fact was the ratio, that the court would consider itself to be bound by it. Okay, so this is an important thing. Courts do not, while deciding, spell out or cull out the ratio of the decisions that they are making. Judicial guidelines. Now, this is important. Sometimes what happens that though we say judicial precedent, it is the ratio which constitutes judicial precedents, but sometimes, like is the case with legislations, judgments of the Supreme Court or High Court may actually give guidelines which are like the black letter law, which is to be followed by everyone. Now, these are, for all practical purposes, akin to legislative laws. And yet, we say that this is not a law made. Now, why this happens? Because the court believes that if these guidelines are not followed, the actions of the executive will always be contrary to law. And therefore, in order to make the act of the executive in line with law and the due process, the court sometimes considers itself to be duty bound to give guidelines. And those guidelines, for all practical purposes, are akin to legislative laws, because these are not precedents, these are not, in a way, decisions, these are simply laws drafted by the court to be followed in future. And that is what the legislature also does. But there is a reason as to why courts do that. Courts do that because courts believe that if these guidelines are not followed, and therefore guidelines must be given, and if these guidelines are not adhered to by the executive will always be acting contrary to law or contrary to the due process of law. And that is why adhering to these guidelines becomes important. Like in Vishaka versus State of Rajasthan, the Supreme Court famously gave what is known as Vishaka guidelines, where the Supreme Court stated that wherever women employees are working in an organization, be it public or private, there has to be an institutional mechanism against the sexual harassment of women, the working women at the workplace. And this has now also become law. Parliament has subsequently enacted a law on that after more than a decade of this judgment. Till that time, for more than a decade, the Vishaka guidelines were actually the law of the land. Likewise, Lakshmikant Pandey versus Union of India, this is a judgment where the court gave guidelines about the adoption, which is inter-country adoption. So if an Indian child is to be adopted, say for example in England, then what is the procedure that must be followed for that? Again, if that procedure is not followed, it may result in violation of law, it may result in violation of the rights of the child, and that is why the court would be giving guidelines. In D.K. Basu versus State of West Bengal, the court gave guidelines so as to identify the rights of the arrested person. So sometimes the legislative law may be incomplete, may be inadequate so far as the rights of the arrested person is concerned. And that's why, in order to ensure that the rights of the arrested persons are not violated and the police is following the due process, the court gave guidelines in DK Basu versus State of West Bengal. Likewise, in Shatrughan Chauhan versus Union of India, mind you, these are not exhaustive examples. There are innumerable judgments where guidelines have been given. These are just illustrative of what the courts may do while adjudicating. In Shatrughan Chauhan versus Union of India, the Supreme Court gave guidelines which the government must follow before it decides to implement a punishment of death penalty. That means when death penalty is to be executed, what steps must be undertaken by the government so as to ensure that the rights of the person who is to be executed are not violated and that the execution follows the due process of law. Okay, so this is an important thing, that the courts sometimes also give guidelines which are almost like legislative laws, yet even these laws are not considered examples of law made, because these are given because the court consider itself to be constrained to do so, unless otherwise it will result in violation of law, it will result in violation of the rights of the persons, it will result in violation of the due process of law, and that's why the courts give guidelines. Now we'll come to some examples of the judgments which though decide the case but does not give rise to a binding judicial precedent. Why this happens? Now, there is this concept of judgment per incurium, which is an exception to the rule of stare decisis, that is, to stand by what has been decided and not unsettle it. A decision rendered by ignoring a binding precedent or in ignorance of the terms of the statute or a rule having the force of law, then such a judgment is a judgment per incurium, and therefore the reasons advanced in such a judgment would not give rise to a precedent. So what is this concept of judgment per incurium? That a decision rendered ignoring a binding precedent or ignoring the terms of the statute or a rule having the force of law. So if there is a precedent that exists and it has been ignored, if there is a statute that exists and it has been ignored, or if there is a rule that exists, it has a rule of law that exists and that has been ignored, and the judgment has been passed in ignorance of it, then that judgment becomes a judgment per incurium, because the applicable law itself has not been applied, and therefore the judgment would not give rise to a precedent. Recently, the Supreme Court in 2024 in Bilkis Yaqub Rasool versus Union of India declared a 2022 judgment of the Supreme Court in Radheshyam Bhagwan Das Shah versus State of Gujarat to be a judgment per incurium, having been delivered ignoring the existing judicial precedents of the Supreme Court. In Radheshyam Bhagwan Das case, the Supreme Court ignored the existing precedents, and that's why when it was found out in 2024 in Bilkis Yaqub Rasool case, the Supreme Court declared the Radheshyam judgment to be a judgment per incurium. An associated concept with per incurium is the concept of judgment sub silentio, which is also an exception to the rule of stare decisis. When a particular point of law in a decision is not perceived by the court, or not present to its mind, or is not consciously determined by the court, and it does not form part of the ratio decidendi. Now, what does that mean? When a particular point of law in a decision is not perceived by the court, or not present to its mind, or is not consciously determined, and it does not form part of the ratio, then that kind of decision becomes a decision sub silentio. Now, what happens is that sometimes the court may actually decide a question, but that decision may not have taken into account every possible thing that ought to be taken into account while making that decision. And if it is proven that the court, while deciding that question, did not take into account some of the important factors which ought to have been taken into account while making that decision, then that decision on that particular factor not considered is silent. And that's why, because it is silent on those factors which are central to the determination of that question, the judgment is termed sub silentio judgment. And because it is a sub silentio judgment, therefore the question that was decided remains in a way undecided, and therefore it does not give rise to a binding precedent. Example, in Abhimit Sinha versus High Court of Judicature at Patna 2024, the Supreme Court declared All India Judges Association versus Union of India 2002 to be a judgment sub silentio on the question of minimum cutoff marks in the interview. Now, in this case, the court was actually examining a recruitment rule which prescribed minimum cutoff marks in the interview. And the petitioner has challenged that the interview should not have minimum cutoff marks. From the High Court side, it was the High Court side, the Indian Judges Association 2002 judgment was cited, where the Supreme Court had written in its order that interview should not have minimum cutoff marks. But the court in 2024 declared this observation of the 2002 judgment of the Supreme Court to be a sub silentio judgment, because the court said that this is simply written in the judgment of the court, but this issue was not agitated before the court. So there is no reasoned adjudication of this question that had taken place in the 2002 judgment. The court nevertheless expressed its opinion, but that opinion was not well informed because it was not adjudicated. It was not agitated by the parties, and hence many of the factors which ought to have been considered while making such an observation were not considered. And that's why this particular observation of the court passed sub silentio, and that's why it cannot be said that there exists a precedent of the Supreme Court which says that there should not be minimum cutoff marks for interview. And that's why the 2024, the Supreme Court is not bound by this 2002 judgment of the Supreme Court. So that's how judgment sub silentio operates. Now, coming to some of the important attributes of judicial precedents which are applicable to the Supreme Court itself. So this is about how the Supreme Court judgment binds the Supreme Court. So the Supreme Court of India in Central Board of Dawoodi Bohra Community versus State of Maharashtra, it's a 2005 constitution bench. The court discussed the legal precepts which apply to the orders of reference and reiterated the position of law as below. A. Decisions of this court rendered by a bench of larger bench are binding on the benches of a less or equal strength. Okay, so the court is saying we know that constitutional courts, high courts and Supreme Court sit in benches. High court may have single judge bench or double judge bench, and sometimes what is called full court, the 3-judge bench. Whereas the Supreme Courts generally sit as two judge benches. But in the Supreme Court also there can be 3 judges bench, there can be 5 judges bench, there can be 7 judges bench, there can be 9 judges bench. In Keshwan and Bharati, the bench strength was 13. So therefore the question of bench strength becomes important. So the Supreme Court in 2005 is saying that decision of this court, that is Supreme Court, rendered by a bench of larger strength are binding on the benches of less or equal strength. Equal strength is also. So if a 3-judge bench has given a judgment, the precedent will bind the future 3 judges bench also, but it will not bind the discretion of a future 5 judges bench. And obviously a bench of lesser bench strength is bound by that judgment. If a bench of lower strength is doubtful about the correctness of a judgment delivered by the bench of larger strength, it cannot disagree or dissent from the view taken by the larger bench. So that's an important thing. It cannot disagree or give its dissent. In case of doubt, it can invite the attention of the Chief Justice of India to its opinion and request the Chief Justice to list the matter before a bench, the strength of which is greater than that which delivered the judgment which has been doubted. That means the bench of lower strength cannot simply disagree with a judgment of the larger bench strength, but it can express doubt about the correctness of the same. However, in that case, the bench of the lower bench strength will have to refer the matter to the Chief Justice of India to its opinion and request the Chief Justice to list the matter before a bench of larger bench strength compared to the bench strength of the judgment which has been doubted. C. The correctness of the view taken by any bench can only be doubted by a bench of equal strength. Now, this is slightly confusing. So confusing so far as B and C is concerned, because that says it cannot be dissented, and here it is saying that only, and yet in guideline B, the bench of lower bench strength can also, after expressing the doubt about the correctness, may refer the matter to the Chief Justice. Now, if you read C, the correctness of the view taken by any bench can only be doubted by a bench of equal strength. Now, there is a contradiction slightly in B and C. So, because B also, that means the lower judge bench strength can also doubt, okay, and refer the matter. The matter will then be placed before a bench of greater strength. Now, here what happens is that in clause B, it is categorically written that if that the lower bench cannot disagree or dissent. Okay, doubts can be expressed. Like if you see the first sentence of guideline B, if a bench of lower strength is doubtful about the correctness, okay, and here it is saying the correctness of a view taken by any bench can only be doubted. So obviously, in terms of first sentence of B and C, there is a contradiction, but this is there in the judgment itself. So there, it has to be read in a manner so that this contradiction is reconciled. Now, the contradiction can be reconciled in this way, that so far as expressing the doubt is concerned, the doubt can be expressed by the bench of equal bench strength as well as the bench of lower bench strength. However, the bench of lower bench strength cannot disagree or dissent, in the sense that it cannot give a judgment contrary to the judgment of the existing judicial precedent of the larger bench. Whereas a coordinate or the same bench strength, apart from doubting the correctness of the existing precedent, may even disagree with that precedent and give a judgment. Okay, so that's how these two apparent inconsistencies can be reconciled. There are two exceptions to the rules discussed above. The discretion of the Chief Justice is not bound by the rules. That means a bench may refer the matter to the Chief Justice, but the Chief Justice is not bound by the reference. As the master of roster means what matter will go to which bench and how the bench will be constituted, including the bench strength. So as master of roster, the Chief Justice may list any case before any bench of any strength. So complete discretion of the Chief Justice. Despite the rules discussed above, if a particular case has come up for hearing before a bench of larger strength and that bench is of the opinion that the judgment of the bench of the lower strength requires reconsideration or correction or is otherwise doubtful of its correctness, it may dispense with the need for a reference in the terms described above or an order of the Chief Justice and hear the matter for the reasons given by it. That means if the court decides, if a larger bench strength comes to a question of a lower bench strength, but that does not form part of the reason as to why the larger bench was constituted, the larger bench is still free to hear the parties on the precedent which it considers to be doubtful. And accordingly, after hearing the parties, it may even decide to overrule that precedent without that question being part of the reference for which the larger bench was actually constituted. These guidelines of Dawoodi Bohra judgment were also reiterated by the Supreme Court Constitution Bench in Aligarh Muslim University versus Naresh Agrawal 2024. Now we'll see a few questions based on what we discussed. The system of binding judicial precedent is followed in common law countries that we saw. A. Judicial precedents are a source of law because judges make law. No, judges don't make law, but the interpretation of the existing law becomes law, appears to be right. Judges do legislate. No, all of the above. So option B is the right answer. Obiter dicta of the Supreme Court is not binding. Is a law? No, not binding. Option B. Ratio decidendi of a judgment is the reason for the decision. Option C. A judgment per incurium is not a binding precedent. It cannot be persuasive also. It is not a binding precedent. Option B. 6. A judgment sub silentio is a decision on an issue in which the applicable questions of law were not examined by the court. Examined by the court, decided. Option A, not examined by the court. That's why it is silent on those questions, and hence it is a sub silentio judgment. A judgment of the Constitution bench of the Supreme Court is binding on the bench of equal or lower bench strength, correct? A bench of lower bench strength, a bench of higher bench strength. No, cannot be. So a bench of equal or lower bench strength. Option A is the right answer. The Supreme Court of India in Bilkis Yaqub Rasool versus Union of India declared the judgment of the Supreme Court in the below mentioned cases to be a judgment per incurium. We just saw it. Radheshyam Bhagwan Das Shah versus State of Gujarat. Option A. If a bench of a lower strength is doubtful about the correctness of a judgment delivered by the bench of larger strength, it cannot disagree with the judgment of the larger bench. Yes, it can decide contrary. No, it cannot decide contrary. That can only be by a bench of same bench strength. Can disagree with the judgment. It cannot. So therefore, option A, it cannot disagree. It can express doubt, but it cannot disagree. So option A is the right answer. And finally, in the Supreme Court, the correctness of the view taken by any bench can only be doubted by a bench of lower bench strength, equal bench strength, any bench strength. Correctness of the view taken by a bench can be doubted by any bench strength, because even the lower bench strength can lower, equal, higher, all can express the doubt, and that's why any bench strength is the right answer. So option C is the right answer. So that is it on judicial precedents. Thank you very much.